Hello there. Today we're going to talk about the Assisted Human Reproduction Act, but moreover we're going to take a look at general constitutional law analysis on an issue where many provisions in a federal statute are challenged. And we will do this by way of a case brief on the Assisted Human Reproduction Act reference from 2010. In other words, and in simpler form, we're going to look at the work of a judge who is much more capable of analysis than myself. At least this is quite well done. This case is quite well done. So let's go ahead and dive in. So the summary of this case. We have two parties, the Attorney General of Canada and the Attorney General of Quebec. And these parties disagree on the proper characterization of the Assisted Human Reproduction Act. So, Attorney General of Canada says that the dominant purpose and effect of the legislative scheme here is to prohibit practices that would undercut moral values, produce public health evils, threaten the security of donors, donees, and persons conceived by assisted reproduction. The AG of Quebec, however, says the dominant characteristic here is the regulation of reproductive medicine and research. And these different characterizations of the scheme lead to different results at the second step. So the Attorney General of Canada says the law is valid federal legislation under the criminal law power. AG of Quebec says a legal scheme to regulate health concerns that fall under provincial powers. Okay, so big major issue here. Is the Assisted Human Reproduction Act properly characterizes legislation to curtail practices that may contravene morality, create health evils, or put the security of individuals at risk, as the AG of Canada contends? Or should it be characterized as legislation to promote positive medical practices associated with assisted reproduction, as the Attorney General of Quebec contends? So some questions that come up here in Pith and Substance. What is this legislation about? Is it about controlling and curtailing negative impacts associated with artificial human reproduction? Or is it about establishing salutary rules to govern the practice of medicine and research in this emerging field? So we will break down the constitutional law analysis here, much like we might do on the fact pattern of an NCA exam or law school exam. Okay, big issue. Whether a scheme, this legislative scheme as a whole, is a valid exercise of federal power, and as to whether the individual challenged provisions are valid. So the different provisions in there. So they're not saying the whole thing is invalid, they're just saying most of the provisions are. So because of that, we're going to look at both. Okay, so let's talk about the rules on that. And you'll find this is basically, this whole case brief is done in an extended IRAC format, examining the issues, the rules, the analysis, the conclusion. So let's continue. So big rule, the court would begin by examining, normally they would do this, the impugned provisions, if it's just a few provisions, and to determine if and to what extent they intrude on the provincial sphere of competence. So that's from the Kirkby case. The advantage of doing it that way, by looking at the individual ones, is that if those provisions are found not to intrude, then the investigation need go no further. General Motors case. So, while courts may nonetheless examine the whole scheme in such cases, sure, we have tended to end the analysis if the individual provisions are not found to be problematic. Case Ward. Okay, when individual provisions of a federal scheme are challenged, the court must examine the entire scheme and impugn provisions separately. That's from City National Leasing case. The court has often underlined that the impugned provisions must be considered in their proper context, in the reference of the Employment Insurance Act, next rule, there are two steps in determining whether a law is valid: characterization and classification. First, the dominant matter or the pith and substance of the law must be determined. Canadian Western Bank case. Once the matter is thus characterized, the second step is to determine if it falls under a head of power assigned to the enacting body. Kit Catla Band case. To determine which characterization is correct, one must consider the purpose and effect of the legislative scheme. One must ask, what in fact does the law do and why? The doctrine of pith and substance permits either level of government to enact laws that have substantial impact on matters outside its jurisdiction. And the issue in such cases is to determine the dominant effect of the law. Okay, so now we have our rules. Now in this case, the judge is going to apply the fact pattern to the rules in a process known as analysis. Let's check out his analysis here. Viewed as a whole, the dominant effect of the act is to prohibit a number of practices which Parliament considers immoral, and or which it considers a risk to health and security, not to promote the positive aspects of assisted reproduction. The dominant effect of the prohibitory and administrative provisions is to create a regime that will prevent or punish practices that may offend moral values, give rise to serious public health problems, and threaten the security of donors, donees, and persons not yet born. In sum, well, the act will have beneficial effects. One hopes all criminal laws will have beneficial effects. And while some of those effects may impact on provincial matters, neither its dominant purpose nor its dominant effect is to set up a regime to regulate and promote the benefits of artificial reproduction in hospitals and laboratories. Conclusion here, turning to the effects of the act, this legislation clearly has an impact on the regulation of medical research and practice and hospital administration. Researchers, practitioners, and hospitals will be subject to both the act and the regulations it contemplates. The judge concludes here that the pith and substance of the act is properly characterized as the prohibition of negative practices associated with assisted reproduction. So far, we have passed the characterization test. The next issue is whether this legislation comes within the scope of the federal criminal law power under Section 91 of the Constitution Act. In order to answer this question, we must consider whether the matter satisfies the three requirements of valid criminal law. Three requirements being 1, a prohibition, 2, backed by a penalty, and 3, with a criminal law purpose. This is from the Firearms Act reference. Okay, some of the rules here for this issue. From the Morgenthaler case, the criminal law does not require absolute prohibitions. Such schemes permit flexibility, vital in a field of evolving technologies, and they have repeatedly been upheld as valid criminal law from the RJR-Macdonald case. A stricter provincial scheme would complement the federal criminal law. See the Rothmans, Benson, and Hedges v. Saskatchewan case, and Irwin Toy, of course. As already discussed, the Act, this is the analysis, as already discussed, the Act, properly characterized, as we've already tested, imposes prohibitions backed by penalties, thereby fulfilling the first two requirements of a valid criminal law. Imposing prohibitions being backed by penalties. Admittedly, some of the provisions permit exceptions in this case. To be sure, a large portion of this scheme is regulatory, and it is open to Parliament to create regulatory schemes under the criminal law power, provided they further the law's criminal law purpose. So the complexity of modern problems often requires a nuanced scheme consisting of a mixture of absolute prohibitions, selective prohibitions based on regulations, and supporting administrative prohibitions. So, the requirement that a criminal law contain a prohibition prevents Parliament from undermining the provincial competence in health. The federal criminal law power may only be used to prohibit conduct and may not be employed to promote beneficial medical practices. Federal laws, such as the one we're talking about here, may involve large carve-outs for practices that Parliament does not wish to prohibit. However, the use of a carve-out only means that a particular practice is not prohibited, not that the practice is positively allowed by the federal law. So this has important implications for the doctrine of federal paramountcy. Conclusion here: there may be a conflict between a criminal law and a less strict provincial scheme. However, in such a case, the Parliament's stricter scheme would be acting as a prohibition. In this way, the prohibition requirement for criminal laws acts as a major limitation on the effects of Section 91, subsection 27. Next issue: does the Act serve a valid criminal law purpose? So, having determined that the Act imposes prohibitions backed by penalties, it remains to be determined whether it does so in the service of a criminal law objective. Rules here: a criminal prohibition must serve a public purpose, like peace, order, security, health, morality. Stopping short of pure economic regulation, it has been held that highway regulation bearing no relation to public safety falls beyond the scope of the federal criminal law power, Boggs v. the Queen. On the other hand, prohibitions aimed at combating the public health evil of tobacco consumption have been found to fall within the ambit of the criminal law power, RJR-Macdonald, as have prohibitions directed at protecting the public from environmental hazards, Hydro-Quebec, dangerous and adulterated food and drug products, dangerous and adulterated food and drug products from R.V. Wetmore, illicit drugs from Malmo-Levine, and firearms from the Firearms Reference. Analysis here: the AG of Canada relies on these cases to argue that prohibiting the detrimental aspects of assisted reproduction constitutes a valid criminal law purpose under the objectives of morality, health, and security, including the protection of vulnerable groups. The Attorney General of Quebec criticizes this approach, arguing that it represents a virtually unlimited extension of the criminal law power, which would threaten the constitutional division of powers between the federal and provincial governments. Further analysis here: this judge says there's merit in both positions. So on the one hand, the jurisprudence properly recognizes that confining the criminal law power to precise categories is impossible. The criminal law must be able to respond to new and emerging matters of public concern that go to the health and security of Canadians and the fundamental values that underpin Canadian society. A crabbed categorical approach to valid criminal law purposes is thus inappropriate. On the other hand, a limitless definition combined with the doctrine of paramountcy has the potential to upset the constitutional balance of federal-provincial powers. So both of these extremes must be rejected. To constitute a valid criminal law purpose, a law's purpose must address a public concern relating to peace, order, security, morality, health, or some similar purpose. At the same time, extensions that have the potential to undermine the constitutional division of powers should be rejected. Next issue, quick one here. So whether a federal law falls within Parliament's criminal law power under Section 91(27) is a question of which level of government has jurisdiction to enact this law. And this question relates to the powers of one level of government vis-a-vis the other, and it is resolved by determining the law's pith and substance. Conclusion here: it follows that this case does not require us to balance the impact of the Act on liberty against the importance of Parliament's legislative objective. So we're skipping that test here. And then issue on to whether this Act comes within the scope of Section 91(27) entirely. The rule here: criminal law may target conduct that Parliament reasonably apprehends as a threat to our central moral precepts from the Malmo-Levine case. And Parliament need only have a reasonable basis to expect that its legislation will address a moral concern of fundamental importance, even if hard evidence is unavailable on some points because the jury is still out. Again, from the Malmo-Levine case. Conclusion here, upholding morality is the principal criminal law object of the Act, and morality constitutes a valid criminal law purpose. The role of the courts is to ensure that such a criminal law in Pith and Substance relates to conduct that Parliament views as being contrary to our central moral precepts, and that there is a consensus in society that the regulated activity engages a moral concern of fundamental importance. Okay. So a simple phrasing of that would be yes, it does. The Act comes within the scope of Section 9127. Issue: whether this criminal law can be used for the protection of health. Okay, rules here. Criminal laws for the protection of health must address a legitimate public health evil from the RJR-Macdonald case. And it has been held that the federal criminal law power encompasses the regulation or prohibition of threats as diverse as tobacco, RJR-Macdonald, dangerous and adulterated food and drug products, Wetmore, illicit drugs, Malmo-Levine, gun control, Firearms Reference, and environmental degradation from Hydro-Quebec. This being said, the need to establish a reasonable apprehension of harm means that conduct with little or no threat of harm is unlikely to qualify as a public health evil. Malmo-Levine again. Parliament is entitled to use the criminal law power to safeguard the public from conduct that may have an injurious or undesirable effect on the health of members of the public, notwithstanding the province's general right to regulate the medical profession. Health is subject to overlapping federal and provincial jurisdiction, and the province's power to legislate in this field does not exclude Parliament's authority to target conduct that constitutes a public health evil. RJR-Macdonald. So, analysis here. This is what the judge is thinking here. So, behind the diversity in the cases that have upheld criminal laws on the basis of public health evils lie three constant features. In each of these cases, the criminal law was grounded in 1. Human conduct that 2. has an injurious or undesirable effect. 3. On the health of members of the public. Human conduct causing harm is the fundamental stuff of criminal law. The element of harmful human conduct transforms a public health problem like cancer into a public health evil like tobacco. The criminalization of public health evils recognizes that criminal liability is not confined to crimes like murder and fraud, where human conduct is coupled with injury to a specific person. Parliament is entitled to target conduct that elevates the risk of harm to individuals, even if it doesn't always crystallize or manifest in injury. For example, Parliament may criminalize dangerous driving despite the fact that it creates only a risk of injury, not a certainty. Where human conduct may cause injurious or undesirable effects on the health of members of society, Parliament may prohibit it as a public health evil. So no constitutional threshold level of harm as such constrains Parliament's ability to target conduct causing these evils. It is not apparent that the criminal law may only regulate the severest risks to the individual's health and safety, and not also prohibit less severe harms that are of public concern. So, conclusion to the issue as to whether this criminal law can be used for the protection of health? Yes, it can. It can be used. Okay. So then we take a look at the issue of security here. So is this, to answer the security question, we say, is this legislative scheme grounded in a valid criminal law purpose? So we have a rule here from Rothmans, Benson, and Hedges versus Saskatchewan that double occupancy of a field of endeavor, such as health, is is a permanent feature of the Canadian constitutional order. It leads to a standard double aspect analysis under which both aspects subsist side by side, except in case of conflict, when the federal power prevails. Analysis here, the purposes of the criminal law overlap, federally and provincially. Morality, public health, evils, and security may focus on the same concerns. It can do that. In exercising its criminal law power, Parliament is not confined to a single purpose or given combination of purposes. What is required is that the legislation, properly characterized and considered in light of the various objectives advanced, serves legitimate criminal law purposes. So, in conclusion, this legislative scheme is not directed toward the promotion of positive health measures, but rather addresses legitimate criminal law objects. So, that's basically looking at this case as a whole. And as a whole, this case is considered grounded in valid criminal law purposes. Again, that's not what they're suing for, but that's for the first analysis because the provisions in question can constitute a major portion of this legislation. Therefore, this judge looked at it as a whole first and found it to be valid, which raises the question then, now that that's determined to be valid, whether the individual prohibitions of the Act constitute valid criminal law. So do the individual prohibitions, how are they looking here? So let's look at some rules here. And invalid legislative provision is not rendered valid merely because it is included in a legislative scheme that viewed globally is valid, General Motors case. Sub-issue here as to whether the provision, considered in the context of the larger scheme of the Act, is valid criminal legislation in terms of prohibition, penalty, and criminal law purposes. And so the rule here that the judge is basing this analysis on is that extensive and comprehensive regulatory schemes were found to be valid criminal law in RJR-Macdonald and in the Firearms Reference. Okay, so you can get complex here. And the judge states that the first point is that the extent of comprehensiveness of a criminal law regulatory scheme does not affect its constitutionality. Provided a regulatory scheme reflects and furthers proper criminal law goals, it remains securely anchored in the federal criminal law power. The dominant character of the prohibitions in subsections 5 to 7 is to criminalize conduct that Parliament has found to be fundamentally immoral, a public health evil, a threat to personal security, or some combination of these factors. The judge goes on to test, using this test and using this analysis against this rule, each section of the legislation and found them all to be valid. And the judge says, in conclusion, in Pith and Substance, the prohibitions come within the scope of the federal criminal law power and are valid criminal law. So then the issue, the judge wants to look at whether the administration and enforcement provisions in the Act are valid. So the policy, sure, that's valid. But the question is whether these administrative provisions of the Act are ancillary to the prohibition regime in sections 5 to 13. So the rule here, and this one is not exactly sourced, but the Ancillary Powers doctrine holds that legislative provisions which, in Pith and Substance, in their main purpose, fall outside the jurisdiction of the government that enacted them, may be upheld on the basis of their connection to a valid legislative scheme. So they're connected within the whole, and then individually they might not be held, but they're connected within the whole, then they could still be valid. That's the rule here. So the court has developed a rational functional test to describe the required connection, with the caveat that a test of necessity will apply where the encroachment on the jurisdiction of the other level of government is substantial. General Motors case. The idea of proportionality underlies the idea of a rational and functional standard for some cases and the standard of necessity for others. The more an ancillary provision intrudes on the competency of the other level of government, the higher the threshold for for upholding it on the basis of the Ancillary Powers doctrine. Analysis here in General Motors, Judge Dixon noted a number of factors that would determine the severity of an extra-jurisdictional incursion, and the factors may be summarized as follows. First factor, scope of the heads of the power in play, whether they're broad or narrow. Broad heads of powers lend themselves to jurisdictional overlap, and therefore less likely to give rise to intrusive provisions. This is from General Motors. This stands in contrast to narrow heads of power, which are quite susceptible to having provisions tacked on to legislation which is validated under them, again from General Motors. So Dixon concluded that the intrusion on the powers of the other level of government will usually be less serious where the impugned provision appears in a legislative scheme that is validated under a broad head of power. This logic says that it's also important to consider the head of power that the impugned provision itself is said to infringe. If it intrudes upon a broad head of power, the intrusion will generally be less serious because it does not overwhelm the jurisdiction of the other level of government. Conversely, an intrusion on a narrow legislative competency will be more serious because it threatens to obliterate the head of power. So they're basically saying that the DMV should not have a provision to, the Department of Motor Vehicles should not have a provision to regulate doctors. However, the province of BC might have a provision to regulate doctors, whereas so does the government of Canada, and then it's not so bad. Okay. Second factor here concerns the nature of the impugned provision. Judge Dixon and General Motors considered the intrusion on provincial powers less serious because of the nature of the impugned provision in that case was remedial. It was designed to help the substantive aspects of the act, but in itself was not substantive. And he also noted that the incursion on the jurisdiction of the other level of government would be less serious where the impugned provision was limited in scope and did not create general rights. Another relevant aspect of the nature of the impugned provision is whether it is intended to replace legislation introduced by the other level of government, or is it to merely supplant it. An intrusion will be less serious when the impugned provision is meant to coexist with legislation enacted by the other level of government. Finally, Judge Dixon considered whether the impugned provision's enacting body had a history of legislating on the matter in question. A history of legislation in the area supports the legitimacy of impugned provisions and suggests that they will not prove unduly intrusive on the other level. Thus, the enacting body is not constitutionally precluded from enacting similar legislation where such measures may be shown to be warranted. In General Motors, it sufficed that Parliament had a history of intruding on provincial jurisdiction by creating rights of civil action. This track record demonstrated that the inclusion of such a right was not constitutionally fatal. Sub-issue here, the question is whether these provisions, taken as a whole, represent a minor incursion on provincial powers or a substantial one. Or sub-issue, or is that a recap of the issue? The rule comes from Firearms Reference in Hydro-Quebec that these historical comparisons suggest that the ancillary provisions constitute only a minor intrusion on provincial powers. This judge in the analysis first considers the scope of the provincial head of power in play. In present appeal, the ancillary provisions generally fall under the provincial powers over property and civil rights and matters of a merely local or private nature. Both of those are very broad head of powers. They're often seen as sources of residual jurisdiction, which makes that much less serious. Second factor, the nature of the ancillary provisions. So they're not creating an actual substantive right. They merely function in enforcement. So these provisions would serve no purpose. Otherwise, they would establish an agency with nothing to enforce. And everything is consent is obtained, information flows, privacy is protected. All this is done to ensure the smooth functioning of the criminal prohibitions. And then these ancillary provisions are tailored to a small corner of the vast topography of the provincial power over health. So the impact on the law on provincial powers is real, but it's confined in a manner consistent with the purpose of the Act. Furthermore, the ancillary provisions are designed to supplement rather than exclude provincial legislation. So the conclusion that follows: the Act imposes federal rules on the practice of assisted reproduction, but it does not prevent the provinces from regulating this field, especially for the promotion of its beneficial aspects. So in light of these factors, this judge concludes that the ancillary provisions constitute a minor incursion on provincial jurisdiction. Accordingly, though, finally, the rational and functional connection test should be applied in this case. The rule here that the rational and functional connection test assesses the relationship between the ancillary provisions and the otherwise valid legislative scheme in which they appear. So the ancillary provisions must support the scheme in a way that is rational in purpose and functional in effect. This means that they must complement rather than supplement the legislative scheme. It's from the PAP case. It also means they must be appropriately tailored to fill gaps in the legislative scheme that might otherwise lead to inconsistency, uncertainty, or ineffectiveness from the Kirkby case. Issue: whether the ancillary provisions are rationally and functionally connected to the valid criminal law provisions in subsections 5 to 13 of the Act. Analysis: that the collection of information will help to ensure that the Act's prohibitions are respected, and if defied, that such conduct will be effectively prosecuted. So the conclusion is that the subsections were closely tied to the prohibitions, so the ancillary provisions were closely tied to the criminal prohibitions, and that these prohibitions fill a gap by addressing practical considerations inherent in the functioning of the legislative scheme. And because they do so in a tailored manner, they constitute a proper exercise of ancillary powers, and so that all other subsections of this legislation pass this analysis and test. So the ultra mega final conclusion is the main issue of this case and what they were trying to decide here. Do these provisions exceed, either in whole or in part, the legislative authority of the Parliament of Canada under the Constitution Act? And the answer here is no. Click like, click subscribe, check out these other videos on constitutional law, and eventually even more Canadian law and NCA exam prep down here in the corner. And best of luck to you on your upcoming exams.